I'm Amir with the Adibi IP Group. We're intellectual property professionals helping entrepreneurs protect their intellectual property. Today we're going to be talking about intellectual property theft. This is a serious issue that every company and individual has to deal with, because whenever you develop any type of valuable intellectual property, you're going to have to worry about other people taking it without your authorization. You have to be thinking about ways that you can protect your intellectual property so that you're going to be able to gain competitive advantages in the marketplace. The number one thing to understand about intellectual property is that even if you take all the steps necessary to protect your IP, it's still possible that someone is going to actually rip off your intellectual property and take it without your authorization. However, if you don't have IP protected, so let's say you don't have any patents or trademarks, then it's going to be a lot harder for you to do anything about it. What intellectual property does is it gives you a remedy in the event that a party takes your intellectual property without your permission. So if your IP is stolen and you have IP like patents and trademarks, then you're going to be able to do something about it. Budget is a concern for everybody. So the number one thing to focus on is what gives you the greatest competitive advantage in the marketplace. And that's where you should focus your IP efforts. So for example, if you have a widget that works a lot better than your competitors, ask yourself, why does this widget work better? If it's in the way that it's designed, then that's possibly an avenue that you need to consider for protecting it with patents. Now, one consideration is to always protect the brand, at least of your best-selling product, because you might have competitors that are going to try to rip off the name of that brand in order to put out products and trick consumers into thinking that it comes from you. So I would focus on where the value is, where the money is. What gives you the competitive advantage in the marketplace? Is it that you build superior products? If so, consider the products that generate the most revenue and protect those with trademarks. Is your product better than your competitors? Is your service better than competitors? Ask yourself, why is it better? And then you should consider filing patents around why it's better. If your competitive advantage is about creative copy or creative artwork or music, that's a no-brainer. You need to be filing copyrights to protect those forms of expression. If someone is using a mark that's very similar to yours or copies your mark and puts it on their goods and services, you need to contact a legal professional as soon as possible. It's very risky to start reaching out and entering into communications with these possible infringers without at least seeking legal opinion first. Now, a lot of people, for example, will find a competitor on Instagram that has a name that sounds just like theirs or has a logo that looks just like theirs. In those situations, before you reach out, it's strongly encouraged that you at least try to contact an IP attorney, like a trademark attorney or a patent attorney, just to get their legal opinion and their advice. You don't want to be in the situation where you make damaging statements early on in the dispute. The statements that you make are going to be considered admissions, and so those statements could potentially hurt you down the road if the dispute ever gets litigated. So it's a really good idea to first discuss with an IP professional before you reach out and make contact with the other party. Now, additionally, another thing to keep in mind is that communications with your legal counsel are going to be privileged, and so it's going to give you an opportunity to have an actual conversation where you're able to comfortably disclose everything about the issue with your counsel. The same will apply for patents and also copyrights. If you see, for example, that someone's ripped off your product and is selling, say, the same product that you have a patent on, it's really important that you reach out to your patent counsel. You're going to want to discuss it with them and strategize on how to proceed. Now, often what's going to happen is that your counsel may draft what's called a cease and desist letter. The cease and desist letter basically demands that the other party stop, for example, using your mark or stop selling similar products that are infringing your possible patents. So, a really popular form of IP theft is misappropriation of trade secrets. So if you have a trade secret and you have a person, for example, sign a non-disclosure agreement and you tell them your secret recipe, your secret sauce, and then they go off and disclose it publicly, they would be committing misappropriation of trade secrets. And so there's absolutely a remedy for that. And that's why it's so important that if you're ever going to disclose your secret sauce to an independent contractor, you're going to want to have them sign a non-disclosure agreement, or at least, at the very least, have a non-disclosure clause in your independent contractor agreement. This is going to give you some level of protection, and it's going to put them on clear notice that you treat this and consider this to be a trade secret. So definitely look out for intellectual property theft with respect to your trade secrets. Unfortunately, businesses might have employees that work for them for a while, learn about their secret sauce, and then take the trade secrets and then either disclose them or leave the company and then go back and compete with you as their former employer, using the trade secrets that they gathered while they were employed by you. This is a very common form of misappropriation of trade secrets, and it's very important that you act swiftly. You definitely want to contact legal counsel immediately so they can begin the process of stopping this other party from using your trade secrets in their favor against you. Another common misconception is around inventorship. Many engineers at companies develop and come up with ideas that are then patented. Now, the original inventors, initially, when they come up with the idea, they are the owners. Now, what most companies require and have clauses to this effect of are invention assignment. So after the employee invents and then an application is filed, they sign what's called an assignment instrument. So they transfer their rights to the company, to the employer. And so when the employee leaves the company, that patent is still owned by the company. Unless they come up with some special arrangement where they somehow get a license to it or purchase it, that patent is going to remain owned by the company. And so that employee that leaves still cannot practice that invention without exposing themselves to possible patent infringement liability. So another form of IP theft is when an employee leaves and then they go off and start practicing their prior inventions thinking that they own it. That is not the case. Please remember, I am not your legal counsel. If you think that your intellectual property has been stolen, it's very important that you seek and retain counsel immediately so that you can take steps to mitigate the damages that might be caused by IP theft. IP theft is a big deal, especially if you're a business, if you have a lot of intellectual property. It's really important that you take steps to protect your IP.